92.9 WTUG, today's R&B hits and classics. I'm Jade Nicole. Got very special guests in the studio with me today, Mr. Brandon C. Prince and Hannah Thompson from the BHM Law Group. How you guys doing?
We're doing well.
Good.
Doing very well. Thanks for having us, Jade.
No problem. Thank you so much for joining me. A lot of college students sometimes find themselves in trouble, as do average everyday citizens. And sometimes it's not really trouble. Sometimes people just want information on legal issues. They want advice. So we invited you guys to come and talk with us today to answer some of the questions that some of our listeners have. So the first one that we'd like to cover, the question that was sent in says, my child's father is currently in bankruptcy and he's not paying the full amount of court-ordered child support, but he has a withholding order that pays part of the amount, and now he's in arrears with an enormous amount. My question is, can I take him to court to collect the arrears? And if not, can he be discharged from bankruptcy with having so much child support in arrears?
I'll take this question. I think the first thing you want to know is what type of bankruptcy this is. If it's an individual, he's probably typically going to be dealing with a Chapter 13 bankruptcy. And if that's the case, then child support is treated as a priority debt, which means it can't be discharged in bankruptcy.
Okay.
He has to pay it off under the payment plan in order to be discharged, and he has to pay the full amount. Now, what I would recommend is, instead of going to court, filing a separate action, what she needs to do, or he needs to do, is get in touch with the bankruptcy court, the attorney or whomever is handling the bankruptcy for the other side, and make them aware of the debt, because you know you're a debt collector just like the tax man is, and just like the credit card company is. The trustee is who they need to get in touch with. But they're a debtor just like any other debtor, and they would need to get in line with everybody else and make the court aware of that debt. So that's how they would go about doing that.
That was a great answer. I never would have thought of the person being considered the creditor.
Right.
Great response to that question. Okay, so our next question. I was injured at the local trampoline park, and I was wondering if there was any possibility of pursuing a case. Yes, a waiver was signed, but due to what appears to be inadequate safety equipment, floor padding, I suffered 2 broken bones, in my leg, and I've dealt with arthritis and constant pain since, which also caused me to stumble and fall on stairs, causing me to injure my knee. I have also since had to change jobs due to not being able to stand and walk for extended periods of time. I previously worked in food service. Now I have a desk job. I've just been going through a lot since the injury.
So I'll take this question. This is Brandon, BHM Law Group. So when you're dealing with a situation with a waiver, just because you signed a waiver doesn't mean that you don't have a case. A lot of companies will have you sign waivers when you come onto their premises in the hopes that you won't file a lawsuit. But you can always file a lawsuit because there are a number of ways to get around those waivers. The waiver may be inadequate, and then there's certain claims that you can make, such as wantonness claims, which I know is a legalese term, but it's basically a term that said they did it on purpose, or it's so bad that they should have known about it and they didn't do anything about it, that's not going to be covered by the waiver at all. And in a situation like this where you have inadequate safety equipment, it's quite possible that they knew about this inadequate safety equipment, that they knew that the trampoline was dangerous. Maybe they had prior injuries in there. These are all things that could be discovered through the litigation process. But certainly, you still have the ability to file a lawsuit, and I would not be swayed or dissuaded by a waiver.
Oh, wow. Okay. That is great to know, because a lot of times we think that when we sign a waiver, that kind of it frees them of any liability.
And that's certainly not the case.
Wow. Okay. That's a good one. Thank you. Okay. The next question. Is there a statute of limitations for FMLA harassment?
I'll take this one. My name again is Hannah Thompson from BHM Law Group. There is a 2-year statute of limitation on a case for FMLA harassment. So that means you need to contact an attorney at least within 2 years from the time or date that the first FMLA harassment has occurred.
What exactly is FMLA harassment? Just in case somebody else is going through the same thing and they don't know.
Well, it would be someone who is entitled to FMLA time off from their job, and they may be being retaliated against by their employer, such as being threatened to lose their job when they should rightfully be on leave from their job.
Okay, got it. Okay, and there you said 2 years?
2 year statute of limitation to file a claim or file a lawsuit for this type of action. But I would certainly contact an attorney before, not wait to the last minute before you file anything or decide whether or not you have a case.
Okay. Can you take legal action against your landlord if mold keeps coming back in your house? All they do is get some cleaner, wipe it off, paint over it, but it's in the wall.
So the unfortunate reality is that we have a lot of landlords who are maintaining what I consider slums, and they're not taking care of their property. That's not all landlords. You certainly have some landlords out there who are maintaining their property and running great rentals. But for those who are not, there's the Landlord Tenant Act in Alabama. And under that act, landlords are required to maintain the premises in a habitable manner, which means they can't have mold growing in there, can't have leaky pipes,
Right.
can't have a house that has no heat. They have to maintain it in a habitable manner. And so if you're dealing with an issue repeatedly, particularly mold, and you've made the landlord aware of that and they continue to just do the patchwork, there certainly can be a case there that they are violating Landlord Tenant Act because they've been made aware of it. They know that there's a problem. The problem keeps coming back in the exact same place, and the methods that they're trying to remedy it with are not working. So in a situation like that, I would certainly get in touch with an attorney and at the very least have that attorney reach out to the landlord to take additional steps beyond just patching over it.
Our next question says, if you've been convicted of a felony over 27 years ago and you've had no other problems since then, is there a way to get your voting rights back? The crime was credit card fraud. There was a $1,000 bond. She says, I should have fought the charge, but I was young and didn't know any better. I was at work and I was a trainee, so everyone would send me to the store to pick up lunch. They would take turns buying my lunch and putting gas in my car. Come to find out, one lady felt intimidated by my work performance and decided to say I used her card without her permission.
Okay, Jade, I'll take this one. And again, this is Hannah Thompson from BHM Law Group. What you initially need to do is, first thing you need to do is contact an attorney, and we generally provide free consultations via phone. You can text us at our office number as well, which is 205-994-0902. There are routes and possibilities for having your rights, including your voting rights, reinstated if you have completed your sentence, even if your sentence is a felony. Some of those ways are certification for eligibility to vote, but there are, of course, certain petitions to reinstate your voting rights, especially when there are crimes of moral turpitude involved.
All right. And our last question. I was placed on non-adjudicated probation for a felony. I completed the probation without getting into any more trouble. Now that I'm done, how do I have the charge removed from my record?
Thanks, Jay. This is a great question. I'll take this one. I'm Hannah Thompson, again, from BHM Law Group. By saying not adjudicated, it sounds as if you did not enter a guilty plea or possibly entered what's called a conditional guilty plea through a deferred prosecution. And if you have completed the terms of your deferred prosecution, such as through a probationary period, without picking up any more charges or without being arrested during that time period, then the charge should be dismissed, or what is called null pros, pursuant to the deferred prosecution program. If you are looking for having your arrest record removed, then that you would need to, again, consult an attorney to see if you are eligible for what's known as an expungement. We handle expungements as well, so please don't hesitate to call us if you have any additional questions.
So how would they contact you to get any more questions answered?
So, of course, we can always be reached by phone, and our phone actually takes phone calls and text messages. That phone number is 205-994-0902. You can get more information on our website at bhmlawgroup.com or find us on Facebook at BHM Law Group, LLC.